If you've just inherited homestead property in Florida, the next few minutes can save you thousands of dollars and months of headaches. I'm about to reveal the 5 critical pro tips you must know before you make any decision, and trust me, pro tip number 4 will completely shock you. All right, let's dive in. I'm Santiago Cueto, board-certified international business law expert and best-selling author, and I have helped hundreds of families navigate Florida property inheritance over the past decade. Today, we're breaking down the exact roadmap you need when inheriting homestead property in the Sunshine State. Insights that could literally change your financial future. Here's pro tip number 1. Florida's homestead exemption is unlike anywhere else in this country, and this is huge for you as an heir. Here's what most people don't realize. The homestead exemption can save you up to $50,722 per year in property taxes as of 2025. That's up from just $50,000 due to new inflation adjustments. But here's the catch, and this is where most people lose thousands of dollars. The exemption doesn't automatically transfer when you inherit. You have a specific deadline and requirements. You typically have until March 1st of the year following inheritance to file for the exemption. Miss this deadline, you could be paying double or even triple in property taxes. I've seen families pay an extra $8,000 per year because they didn't know this one rule. Here's pro tip number 2. Pro tip number 2 is what I call the portability trap. And this one trips up even experienced real estate investors. If the person you inherited from had Save Our Homes benefits, which caps property tax increases at 3% per year, you might think those benefits transfer to you. Oh, wrong. Here's the reality. Those benefits only transfer under very specific circumstances. You must establish a new homestead exemption on or before January 1st of the 3rd tax roll year after the previous owner abandoned their homestead. And all owners of a jointly owned previous homestead must abandon that homestead for the assessment difference to be transferred. I had a client who inherited a $400,000 home that was being taxed as if it was worth $180,000 due to Save Our Homes. When the benefits didn't transfer properly, her tax bill jumped from $1,800 to $4,200 per year overnight. And pro tip number 3, the hidden costs that nobody talks about in those free inheritance guides you see online. Even if the property was left to you in a will, you'll likely face probate costs. In Florida, attorney's fees alone can range from $1,000 for estates under $40,000 to 3% of the estate value for larger properties. But that's just the beginning. You've got to go to court where the filing fees are $300 to $400, executor bond fees, publication fees around $100 for legal notices, appraisal costs, title search and insurance, and potential outstanding liens or even back taxes. Well, here's what shocked me early in my career. I had a client inherit a free and clear $300,000 home only to discover that $15,000 in unpaid liens and $22,000 in various transfer costs. So always budget for around 3% of the property value in unexpected costs. Here's pro tip number 4. Pro tip number 4 is the game changer that could save you tens of thousands of dollars, and most heirs have no idea this even exists. It's called the stepped up basis, and it's like getting a tax superpower when you inherit property. When you inherit an asset, the IRS allows you to use what's known as stepped up basis. The property's value is reset to its fair market value at the time of the original owner's death, rather than what they originally paid for it. Let's say your parent bought the house for, say, $100,000 in 1990, and it's worth $400,000 when you inherit it. Normally, if they sold it before passing, they'd pay capital gains tax on that $300,000 profit. But when you inherit, your basis, the amount the IRS considers your starting point, steps up to the current $400,000 value. This means if you sell immediately, you pay zero capital gains tax on that $300,000 appreciation. And remember, Florida has no state capital gains tax either. I've helped a family save $45,000 in federal taxes using this strategy. The key is understanding exactly when and how to use it properly. The final pro tip you need to know is your decision timeline, and this determines everything else we've talked about. You essentially have three options. Option 1, keep it as your primary residence. This maximizes homestead and potential portability benefits, but requires you to actually move in and meet specific requirements within strict deadlines. Here's option 2, keep it as a rental property. Great for cash flow, but you lose most homestead benefits and take on landlord responsibilities. And here's option 3, sell the property. This takes advantage of that stepped up basis we talked about, giving you maximum cash with minimal tax impact. And here's the crucial part. Some of these decisions have deadlines. The homestead exemption filing deadline is March 1st. Portability transfers must be filed by March 1st, and you have until January 1st of the third year after abandoning a previous homestead to establish the portability benefits. Waiting too long to decide can cost you thousands of dollars. And there you have it, the 5 critical pro tips every Florida property heir needs to know. Each situation is unique, so I always recommend consulting with a qualified attorney or tax professional who understands Florida inheritance law. Now, if this video helped you avoid a costly inheritance mistake, I'd really appreciate it if you'd hit that like button. It helps more families discover this crucial information. And make sure to subscribe to my channel for more real estate and legal insights that could save you thousands of dollars. Drop a comment below and let me know, are you currently dealing with inherited property? What's been your biggest challenge? I read every comment and often create videos based on your questions. Thanks for watching, and I'll see you in the next one.